All right, thank you all for coming. I have some remarks. Each of the people up here will also have remarks. We are not going to be taking any questions. This is still an open case, technically an open investigation. Because of the interest in the community and some of the statements and information that is out there, and because of the lack of knowledge of the CRC at this point, I feel it is appropriate for me to make some remarks about what it is we're doing so that the community understands exactly what is happening in this case. So thank you very much for coming. This afternoon I would like to discuss the decision that I have made regarding charges referred to my office by the City of Madison Police Department related to the arrest of Genele Laird on June 21st, 2016 at the East Towne Mall. At this time, I have extended an offer to Ms. Laird through her attorneys to participate in and complete the Dane County Community Restorative Court, or the CRC. If Ms. Laird participates in the program and completes this program successfully, she will not face formal charges for the incident that occurred on June 21st. If Ms. Laird does not successfully complete that program, my office has already prepared a criminal complaint that I would file charging Ms. Laird with the following criminal offenses: throwing or discharging bodily fluids at a public safety worker, battery to a law enforcement officer, resisting officer causing soft tissue injury, resisting an officer causing soft tissue injury and obstructing an officer, disorderly conduct while armed, and disorderly conduct. The first three offenses are felonies. The latter three are misdemeanors. Just so if you're keeping count, I read one twice, but that is the disposition. To be respectful to Ms. Laird's right, should she be formally charged in this manner and in compliance with the ethical rules for attorneys and prosecutors adopted by the Supreme Court of the state of Wisconsin, I am limited in what I can say about the details of Ms. Laird's conduct that resulted in her arrest. But I believe that I can share some information about the facts of this case so the community understands why I have made the decision and why Ms. Laird can go to the CRC. I think it is especially necessary in light of the community interest and attention which has surrounded this matter. On June 21st at approximately 5:16 p.m., the Dane County 911 Dispatch Center dispatched City of Madison police officers to East Towne Mall in response to a report that Ms. Laird was out of control and making threats. When the first officer arrived, he had contact with two mall security guards who provided information about Ms. Laird's conduct. Ms. Laird approached the officer and wanted to leave her name and leave the area. The officer told Ms. Laird she needed to stay, and she insisted that she would leave. Based on Ms. Laird's continued indication that she wanted to leave, the officer ultimately decided he had to place Ms. Laird in custody. Wisconsin law and the state and federal constitutions allow an officer to temporarily detain a person while investigating a crime. Ultimately, the officer did attempt to physically grab Ms. Laird, at which point she physically resisted. As many of you may know, from the cell phone video posted online, a second officer arrived and the officers did use physical force to bring Ms. Laird under control. During that time, Ms. Laird did continue to struggle with the officers and spit at them. The officers continued to give Ms. Laird verbal commands. Eventually, more police officers arrived, and the initial officer asked one of them to summons the Madison Fire Department to come and check on Ms. Laird in response to her statement that she could not breathe. Once Ms. Laird was brought under control, the officers transported her to another area by the mall, and the fire department paramedics evaluated her. Eventually, Ms. Laird was taken to a local hospital for medical evaluation and then taken to the Dane County Jail. The Madison Police Department investigated the incident at the mall that occurred prior to their arrival. An officer located a knife in Ms. Laird's backpack, and during the investigation, another officer learned that the knife had been used in a threatening manner towards another person at the mall. Based on the statements made by witnesses at the mall, Ms. Laird was booked into the jail for charges related to her conduct there, as well as the crimes committed against the police officers. Chief Koval contacted me the night of the arrest. I reviewed the reports, and in conversations with the chief and all the victims in this matter, the issue of referral to the CRC was raised. Ms. Laird is eligible for this program based on her age and her lack of any criminal record. However, she was ineligible due to being referred to my office on felony charges. And her crimes having occurred outside of the normal geographic area for the CRC pilot. After reviewing this case and after consulting with the chief and all victims, I decided that this was an appropriate case for an exception to be made. Two important factors occurred to make this possible. The first was that the victims of Ms. Laird's conduct, the person she confronted at the mall security guards, and the two officers most directly impacted by Ms. Laird's conduct, supported this decision. Restorative justice does not work without victims having a voice in the process. Justice is a public good, and people who are victims of crimes must know that their rights to live in a safe and just community are important. I would ask the community to be grateful that despite Ms. Laird's actions, her victims each made the decision that restorative justice made sense in this case. The second was that Ms. Laird accepted responsibility for her actions and indicated that she is willing to participate in the CRC. I have had a chance to speak with Ms. Laird's attorneys and have discussed this issue with them. My understanding is that Ms. Laird does accept that it was her conduct towards her fellow community members, including the officers involved, that caused this incident. Ms. Laird is 18 years old, and I think she has shown maturity by acknowledging that her conduct at the mall and towards the officers was wrong. Had she not created a disturbance, had she not brandished a knife, had she agreed to stay at East Towne Mall while the police investigated, to be taken peacefully into custody, to not physically resist, and to not use spitting and digging her nails into an officer's arm to resist arrest, this case would not have happened at all. Restorative justice is something I support to hold offenders accountable. Research shows that an approach like that used by the CRC can generate greater satisfaction and feelings of fairness on the part of victims and offenders. It can also, for someone like Ms. Laird, reduce her risk to reoffend. Restorative justice is not a place for me to use or send a case to sweep things under the rug or to avoid making difficult decisions. It is a place for this community to work with its young people to build a more just and peaceful community. To that end, I also want to mention that I am disturbed by threatening statements made about the police officers involved in this case and against police officers in general. Threatening a police officer with harm is a crime and will result in an investigation and prosecution. A just and peaceful community means that we do not threaten each other and that we do not fan the fires of hate. Just as we hold our police officers to a high standard, let us also hold ourselves to a high standard and treat with respect our community members who have chosen to protect us and to serve us. I want to thank Ron Johnson from the CRC for being here today to talk to you about his program and how it functions. I want to also thank Chief Koval for being here and for being an advocate through his support in this case for restorative justice. I want to also thank Jim Palmer from the Wisconsin Professional Police Association for being here today. Jim speaks for officers all across Wisconsin. Finally, I want to thank Barb Franks for being here today. Barb was a career prosecutor who retired only to come back as a volunteer to continue to work on issues of community and juvenile justice. I believe Ron, Mike, Jim, and Barb would like to say a few words so you will have a better perspective on this case and restorative justice in our community. I will reiterate, we are not going to be taking questions after the statements. This is still an open investigation and an open potential case where prosecution may be needed. That said, I also want to make sure that the huge step made by these officers and this department back towards the community is recognized, and that all victims in this case are supportive of this outcome and this restorative justice program. I cannot underestimate the importance of this program for this community. Thank you.
Good afternoon. Thank you, Mr. Ozanne. My name is Ron Johnson. I'm the coordinator of the Dane County Community Restorative Court. Let me give a little bit of information, I guess, for a minute about my background. Being that I am new to Madison, I've lived here for 2 years. I was born and raised in Milwaukee. While in Milwaukee, I taught school for many years. I'm a middle school teacher, former middle school teacher and principal. And I worked for about 20 years directing the city's youth gang diversion program. So I worked with the youth gang subculture all over the city and many, and I consulted around the country on the youth gang subculture issue. For about 10 years, I worked with Justice Genele Laird at Marquette University Law School, where I learned restorative justice. Professor Geske is a world-renowned practitioner and expert on restorative justice, and I feel very, very fortunate that I was able to tutor under her in this endeavor. So the Community Restorative Court in Dane County is something that was put together by many, many people long before I got here, and it's an effort to provide law enforcement, not within sort of to replace the current juvenile, I should say, justice system, but to add another tool. And the idea is to provide alternatives to the current system, to give victims a voice and a say-so in the process. The way that it actually works, when we receive a referral, we have what we call a pre-conference, where we sit down and talk to the victims, because we are basically, our program is victim-based, offender-driven, and community-focused. So we give a lot of weight to victims and victims' needs and victims' issues. And victims have the option to be a part of the process from the beginning all through the program. The idea is that we try to find out basically 4 things. What happened? Who's responsible? Who did it? Who was harmed? Who's the victim? And how can we as a community work together to fix this? And in this situation, I think that it's an opportunity here to help to heal this community that has been fractured by this situation and this incident. And I think that restorative justice is an opportunity for us all to work together to try and heal this and to make it right. And make it right for the victims, and to make it right also for the respondent. We call offenders respondents in the community justice world. And so basically, The respondent in this case completes the process. I think what is good is that she has an opportunity, a second chance to complete this process, and then she will not be C-capped, and all charges and fines will be dropped. I think that is a powerful move, not only for the community, but for her. Because if you're C-capped and charged with felonies and you're 18 years old, then you're going to have trouble getting student loans, difficulty getting jobs, difficulty pursuing a career, getting residence, and so on and so forth. So this is an opportunity for this young lady to take responsibility for whatever she did that helped, that involved this situation, but also to be provided with human and community service opportunities to help her straighten out her life, so that she can go on and go to college and finish high school if she hasn't, and receive the kinds of services that she needs to help move her to the next level. Thank you.
So, our officers were contacted by the district attorney's office in the capacity statutorily defined as victims. Victims have an opportunity to be relational and to have some input facilitating what are the appropriate outcomes. And I think that's where this conversation was really able to get kick-started, for which we're grateful. I met with these officers, and I wanted to make sure that they were being heard and that their rationale for participating or considering this option were entirely for all their reasons and not being hijacked or co-opted by anybody else's agenda. When we spoke, the officer said, when you were a sergeant in training and you had the opportunity to talk to us, one of the things that we recall is that any time we go to a call, then Sergeant Koval, you told us no matter what the call is, our priorities are thusly. First, officer and community safety. 2, take and maintain control and restore order to that situation. And 3, strive for the best possible resolutions available. And it was the officers who suggested, who got this moving, to say, Chief, we really want to show that we're committed to the best possible resolutions, given this woman's age and that she had no prior criminal history. We're willing to show the community that we're not just about the rhetorical talk the talk when it comes to restorative justice. We're able to take that leap of faith and see to what extent, in fact, there's a meeting of the minds and that this person can have a second chance at a second opportunity to avoid a criminal record and the stigma that will follow for the rest of their life, and to see if, in fact, we can't holistically look at how we can make for a better outcome for her. And but for the fact of their willingness to take that sort of a courageous look that would otherwise be a traditional, perfunctory criminal intake, we wouldn't be here today, quite frankly. Their biggest concerns, I think, moving on, is to suggest that was their motivation, looking for the most positive and best resolution moving forward. It was not owing to a video that goes viral. That's not what's prompting their crusade. Had nothing to do with it. And there's a separate process that will ultimately be looking at and evaluating the use of force issues independently by the Dane County Sheriff's Department. That is held in abeyance. So they have nothing to gain and everything, hopefully, to win in terms of showing the community that they're putting their money where their mouth is by taking this step. And for that, I think everybody ought to be grateful for their empowering this to go to a different direction. We had an MOU, a memo of understanding about what the protocols are for the Restorative Justice Court. So the district attorney had to ask me for an exemption for eligibility in order for us to take this pilot in a different direction. And my assent was predicated on what the officers' wishes were, and when I was convinced that those were authentic and that they wanted to give this a try, we're willing to waive this. Okay? The other thing is that they looked deeply at your program, Ron, and as they got into it, they saw that the emphasis was positive-based outcomes as opposed to a euphemism for get-out-of-jail card for free. They realized there's some sweat equity involved, there's some commitment and time, and it's a holistic process involving community members. And I think that was an attractive incentive for them to look at it seriously. Of course, what I would be remiss to say is that we do not consider moving forward that this is to be the new normal. When officers are lawfully carrying out their statutory duties and an arrest is timed to be made, then the regular response should be compliance to that request, that lawful request. And we believe that all resisting charges, or those charges that are battery to police officers, whether they result in extensive injuries or otherwise, we expect that the district attorney will still look at these rigorously on a case-by-case basis on the merits, and if those elements are present, that they do their due diligence in making sure that these public servants have the knowledge and the protection that doing a difficult job shouldn't be made more difficult without the support of the prosecuting attorney. And we feel we have that commitment from the district attorney. So that'll conclude my remarks on it, but again, thank you for listening.
Good afternoon. My name again is Jim Palmer. I'm the Executive Director of the Wisconsin Professional Police Association. The largest law enforcement group in the state, the WPPA represents nearly 10,000 members, including those here in Madison. I am specifically here today as the legal counsel for the two officers that were involved in the arrest of Ms. Laird earlier this week, and to speak on their behalf. Due to the fact that threats have been made against both of these officers, I am precluded from discussing information that might serve to disclose their identities and further compromise their personal safety. On that note, the officers have asked me to publicly express their desire that regardless of how some might feel about this situation, that no threats be made against Ms. Laird, her family, or anyone else. I must also note that I am unable to discuss the specific facts relating to the arrest of Ms. Laird, as the officers wish to safeguard the integrity of the independent investigation that is currently being conducted by an outside agency. Apart from that, the officers are confident that their actions were entirely in accordance with their training, departmental policy, the law, and the standards for the use of non-lethal force that are applied to law enforcement officers across the United States. The two officers at the center of this specifically chose to pursue a career in law enforcement because of a genuine desire to serve the public. And they embraced the heavy obligation of that profession to put the well-being of others ahead of themselves. They chose to work for the Madison Police Department because they believed, then and now, that it is a special agency, and that the city of Madison is a special community. They expressed to me their sincere belief that they were especially attracted to the department's dedication to community policing and a philosophy that has as its foundation an effective and meaningful relationship between police and the public they serve. They also recognize that while this didn't occur overnight, this relationship is being uniquely tested presently, and that it has for far longer than many may wish to admit. While meeting with the district attorney at length yesterday, they conveyed their sincere desire to be a part of a potential resolution to these issues, and not simply be the cause of the broader discord that exists between law enforcement and some in the community. The district attorney and the officers together explored how best to serve that objective, and ultimately decided and agreed that it was best for Ms. Laird to be processed through the restorative courts as opposed to the criminal courts. They made this decision with the hopes that Ms. Laird will benefit from a chance at reformation, and that this might help facilitate a thoughtful, community-wide dialogue on the relationship between law enforcement and the people who live here. They expressed their view that we as a community have been here before, and they saw an opportunity to try something different, with the aspiration that it might play some small role in disrupting what has become an unproductive cycle. To be clear, the officers wrestled with this decision. Out of the concern that they have for the safety of their fellow officers, they were leery of doing anything that might send a message that could serve to compromise the safety of their fellow officers. The district attorney has made it clear to them that he shares that concern and that he will forcefully prosecute those who use violence against officers in the line of duty. Also, the officer's decision should not serve as any admission on their part of wrongdoing. They firmly believe that their actions were appropriate and lawful, given their training and the standards applied across the country. But despite the legality of the officer's response, they appreciate that others in this community view the video of their actions differently, whether because they aren't familiar with use of force issues or because they see the video through a lens that is shaped by personal experiences that are very real. But the legality of the officer's actions should not and must not foreclose a collective community-wide examination of whether we can do better. One that includes the diverse voices of leaders throughout the community as part of a shared commitment to focus not only on law enforcement's interaction with the public, but the public's interaction with the police as well. The officers hope their decision can serve as a catalyst to that kind of cumulative public discourse and can begin to heal the relationship between their profession and the people they have sworn to serve. And ultimately, they want to make this community and the city safe forever. Thank you.
Good afternoon. I'm Barbara Franks. I'm a special prosecutor in the Dane County DA's office. As the district attorney indicated, I retired from that office after 27 years of service, but I decided to stay on, as a volunteer, but unpaid volunteer, because I believe in the work that's being done in the community under the leadership of DA Ismael Ozanne. My comments today are made through the lens and the heart of a Black mother and grandmother. I understand that the anger in the Black community is palpable at this moment. I experienced the same pain that the community experienced while viewing the culmination of the incident that began inside East Towne Mall. There was no one more shocked and horrified than I was at that moment. This incident has the potential to define who we are as a community and to perpetuate the anger and distrust between communities of color and the institution that is sworn to protect and serve all communities without bias or disparate treatment, and that's law enforcement. I've worked all of my adult life, my adult career, over 43 years, trying to improve the justice system. But it can't just take a few people here and there. It takes all of us. It's going to take a willingness on both sides to resist standing proudly in our own indignation. It is going to take a willingness on both sides to acknowledge our own complicity in the state of the contentious relationship between the police and communities of color that allow these types of heartbreaking incidents to occur. From my personal experience, most officers are earnestly trying to do their jobs to the best of their ability and to stay alive to go home to their families at the end of the workday. However, for the broader law enforcement community is going to take an acknowledgement that the militarization tactics of yesterday are no longer effective or valid in today's climate. I believe that the Madison Police Department rejected that model years ago when it implemented the concept of community. They get to know people and interact with people, and they also have a personal stake in the communities in which they work. Having said that, it is also going to take an acknowledgement by some individuals that the us against them mentality, which some officers default to, invariably serves to deepen the wedge between law enforcement officers and communities of color. The fact that Chief Koval and the officers involved in this incident are willing to pursue an unconventional resolution to this case is their acknowledgement that change can only come if we all agree that change needs to occur. And they have taken a huge step to jumpstart that change. However, it is going to take additional training content and additional training efforts to realize that young people are not fully adults until their late 20s, when their brains are fully developed and the executive function in their brains regulating impulse control allows them to make the most mature decision at the moment that they can make. Until they get to that point, law enforcement, as part of their protection and service, needs to identify alternative methods of dealing with this group of vulnerable citizens. For communities of color, we have to better prepare our children on how to conduct themselves in situations of intense conflict. Every day they leave the house, we want them to return safely and unharmed. It's natural and understandable that part of their training often involves knowledge of bad things that have happened between Black people and law enforcement, even some injustices that have occurred to loved ones at the hands of police. Many children of color, especially those who have been exposed to big city crime, may suffer from undiagnosed post-traumatic stress disorder, which causes them to react in a different way. In combination with a brain that has not been fully developed, law enforcement techniques that fail to consider these factors can often lead to escalation and an undesirable outcome. Community organizations such as the NAACP, the National Black Prosecutors Association, and others have begun to teach our precious youth how to comport themselves and remain unharmed when they come under police scrutiny. Each parent of color, of a child of color, and every community or village, if you will, also bears the same responsibility to teach our kids. The other way to affect change, if we disagree with how things are being run, is to encourage our young people to become part of that change, up close and personal. That's why District Attorney Ozanne, who's the first and only Black chief prosecutor in this state's history, that's what he's done. He's implemented a number of programs designed to better protect the community, strengthen families, and to protect and preserve the future potential of our young people, while simultaneously holding them accountable for unlawful behavior. The Community Restorative Court, which you've heard about, is one of those initiatives. I believe using the resolution of the Community Restorative Court goes a long way toward healing the rift in our community. It demonstrates that the police, the prosecution, and the community can come together to reach a resolution based on an incident that has shocked this community to its core. This resolution provides the opportunity to peel back the layers of mistrust and engage in an honest dialogue. Regarding issues and perceptions that have been raised by this incident. The CRC has trained exceptional peacemakers in the community. They come from all walks of life. They're attorneys, they're correctional officers, they're social workers, they're business people. They're community members who are concerned about the quality of life in our community. The CRC has the potential to transform this community and improve relationships between decision makers and the community. The question is, do we want to continue to retreat to our respective corners and play the blame game, or do we want to face the issue head on in the manner proposed? I propose that we get to work on healing our community and moving forward.